Okay, good morning, everybody. I am recording the class. We have Mashiwa has also since joined, so we have Paulina and Mashiwa. I hope I'm pronouncing that name correctly. Okay, so I am going to start. Class is being recorded for the students that prefer to be like snuggling in bed during their recess at the moment in this very cold, wet weather. I don't know whether it's cold and wet where you are as well. But where I am, it is rather actually unpleasant this morning, but never mind. At least the class is online, so we can sit inside our houses. I want to just share my screen. Just confirm to me that you can see my screen. It's just a page that I've started typing on. Just give me a thumbs up if you can see the screen. Great. Okay, so we started then last week and Tuesday looking at the law of contracts. Started very, very briefly. Looked at what is a contract, an agreement between two people with a serious intention of bringing about obligations. And then we learned that in order for this contract to be valid and enforceable, obligations, rights and duties that are legally enforceable. In order for this contract to be valid and enforceable, there are 5 requirements that have to be met. If these requirements are not met, the contract is said to be void. If a contract is void, it is a nothingness. It is not enforceable. There are no rights and duties that arise from a contract that is void. It's important that you understand that. In certain instances, however, a contract can be said to be voidable. A voidable contract is a valid contract which remains valid, but it can be set aside because something is wrong with one of the requirements. We will look at that in more detail. Potential assessment question there. Each of the following instances indicate whether the contract is valid. Motivate your answer. I give you a short scenario, like a 2-sentence scenario, and you have to compare, you have to check. Have all 5 those requirements been met? If they are met, the contract is valid. If they are not met, the contract is void. So carrying on then with Unit 2 today, looking at consensus. So the first requirement for a valid contract is that there must be consensus. What is consensus? Consensus is a complete agreement about the same thing, the same understanding. About the obligations. This is very important for a contract, that there must be a complete agreement about the same thing. The parties must be on the same page, so to speak. For example, if Paulina hands her cell phone to Mashiwa, Paulina believes she's giving it to him to use for a while, but he must give it back. He, however, thinks this is a gift, he can keep it forever. Then obviously there is no consensus. They are not on the same page. They do not have the same understanding of the obligations that flow or that are required, the rights and duties. So a complete agreement. How do we reach consensus? Consensus comes about by way of offer plus acceptance. Just to interrupt myself quickly, I am going to go through the notes quite quickly. We've got 4 units that I set aside to do during today's vacation school. I am not going to do them paragraph for paragraph. I am going to essentially the notes, the study guide, the notes are on e-learning. It is your responsibility to download them and work through them. I am just going to go through the most important aspects and point out to you, explain what could potentially cause confusion, explain to you and point out to you what you have to concentrate on. I'm not going to do every single page of the study units. So consensus comes about by way of offer and acceptance. Now, something you need to understand about studying law is that everything has requirements. And in all instances, you need to know these requirements. We had the 5 requirements for a valid contract. Now we're looking at these requirements separately. And for consensus, the first one we're looking at, there are requirements. What are the requirements for consensus? To a large extent, these requirements are often repetitive. Start noticing the patterns. It will make it easier for you to understand and remember. Not going to type out all these requirements. They are in the notes. But just the first one, in order for there to be consensus, the parties must have the serious to become legally bound. So see the pattern. What is a contract? A contract is an agreement with a serious intention to bring about obligations. You need consensus. Requirement for consensus is that you must have the serious intention to become legally bound. If I, in passing and in a joke, say to Paulina, "Ugh, you can buy my car for $10," and she says yes, there's no consensus between us because I did not have the serious intention to sell my brand new car for $10. So there must be the serious intention. Then, of course, it is an agreement. The content must be in common. not only the contents, but also the parties. There must be an agreement as to the parties. If I am offering Paulina a job, I want to appoint Paulina, not Mashiwa. So there must be complete agreement as to who are the parties involved in this contract. Content of the obligations must be in common, and you must be aware of the legal consequences. Only if those four requirements have been met, a variation to that question. I refer to this type of question as structured application, where the number of variations to this question. I can indicate whether there's consensus. To answer that, what do? You look at whether these requirements have been met. Now, how do we reach consensus? As I've already indicated, by way of offer and acceptance. What is an offer? There are also requirements for an offer. You need to look at these requirements. They are in the study guide. Pretty much repetitive of, sorry, what we've said previously. One of the requirements for an offer is that it must be made with a serious intention to become legally bound. So that, once again, serious intention to become legally bound. It's also a requirement for an offer. But an important aspect of the offer is that it must be complete and definite. Complete and definite, you must be able to accept it. By simply saying yes. So if Paulina offers her cell phone to Machiwa for sale, and she says to him, Paulina says to him, Machiwa, you can buy my cell phone. Is that an offer? She's only said, you can buy my cell phone. That's not an offer, because she hasn't stated for what price. So, Machiwa, you can buy my cell phone. He says yes. And then she says, okay, but I want $10,000 for it, for a second-hand cell phone. The law doesn't work that way. Complete and definite, you can buy my cell phone for $1,500. He says yes. So there was an offer coupled with acceptance, which means there will be a contract. It must be complete and definite. That is a very important aspect. Once again, it must be made with a serious intention to become legally bound. It must be intended for the offeree. There must be an agreement as to the parties. If I'm offering my phone to Paulina, Machiwa cannot accept that offer. Paulina, you can buy my phone for $1,500. Machiwa says, yes, I'll take it. I don't have to sell it to him because I didn't offer it to him. Complete agreement as to the parties. Coupled with that, it must be addressed to a particular offeree who must be aware of the offer. These requirements that I've typed out there are incomplete. Please have a look at the complete requirements. As set out in the notes. The question often arises, whether an advertisement made by a shopkeeper is a valid offer. You walk into a shop and there's a sign up offering bread for $10.99. That is an advertisement. Is it binding? Can you insist on buying the bread for $10.99? This might come as a surprise to you, but no. An advertisement is not an offer. An advertisement is merely an invitation to do business. What happens, in fact, when you go into the shop? If you walk into a shop and you take a loaf of bread from the shelf and you take it to the cashier, the shopkeeper is not offering to sell the bread to you. The shopkeeper is not the one making the offer. When you take the bread and you walk to the counter and put it down in front of the cashier, you as customer, you are the one that is making the offer to buy this bread for a certain price, which the shopkeeper can then accept or reject. Have a look at that particular section in the study guide. So, how long does an offer last? How long does an offer last? An offer does not last. Nothing in this world lasts forever. Offers, like everything else, at some stage will fall away. So when does an offer fall away? So I'm just checking something quickly. Firstly, an offer can be withdrawn. An offer can be withdrawn at any stage before acceptance. So I've offered my cell phone to Paulina for $1,500 and told her to accept by Friday. By Thursday, I decide I don't want to sell it anymore. I have full legal right to tell her, no, sorry, I am withdrawing my offer. So it can be revoked at any stage before acceptance. An offer can expire. If I've told her, please tell me by Friday, she cannot come and insist on buying it on Saturday because stage the offer has expired. When do offers expire? Either at a time period as agreed or within a reasonable time. What is reasonable? Reasonable is one of those wonderful law terms that lawyers use if they don't have a specific answer. I cannot tell you reasonable is a month, a week, whatever. It depends on the surrounding circumstances. But if I've offered Paulina my cell phone, would not be reasonable for her to come back 3 months later and say, okay, I'll buy it now. Maybe a week or two might be reasonable, but 3 months for a cell phone, definitely not. If it's a car that I offered, obviously the time period would accordingly be longer. So offers will expire either upon revocation or if the time period has passed. An offer also comes to an end if it is rejected. So once she has said no, she cannot change her mind and come back tomorrow and say, actually, I've changed my mind, I will take it, yes. Once it's been rejected, it will expire. A counter offer. I say you could buy it for $500. She says, no, I'll take it for 1,000. Is in fact a rejection. So if she says, I've said 1,500, she says 1,000. She has rejected my original offer and made me a new offer that she will buy it for $1,500, which I now have the right to either accept or reject. Also, death and legal incapacity. If I die, if I've made the offer, but I die before she accepted it, the offer will lapse, will fall away. Two legal terms that you need to know, which are also quite likely to be assessed in your assessments, which relate to the falling away of an offer, is in the first place an option. The term option, what is an option? And secondly, a right of preemption. Something you need to remember about studying law is that in the first instance, English is a funny language. Legal English is an even funnier language, an even more strange language. And very often there are legal terms which might sound familiar in English, but actually in law have a different meaning. And the concept of an option is related to this. What is an option? We tend to think of an option is you have a choice between one or two options. You could choose the one or the other. In law of contracts, however, the term option has a specialized meaning. An option relates to the lapsing of an offer. An option is, in fact, two different agreements, or there are two different offers. There's the main offer. Main offer, you can buy my cell phone for $1,500. In addition to the main offer, there's a second agreement. Will remain open until a specified date. So I offer my cell phone to Paulina for $1,500. And we agree that she will have the option to buy the cell phone until the end of April. So there's the main offer, cell phone, $4,500. There's a second agreement, the option agreement, that this offer will remain open and available for her until the end of April. If by the middle of April, Mashiba comes to me and says, I will give you $2,000 for that cell phone, I cannot sell that cell phone to him for a higher price because Paulina has the option until the end of the month. And only if at the end of the month does she say, no, I'm not interested in buying it, may I sell it to somebody else. So an option is a main offer coupled with a separate agreement to keep that offer available, keep that offer open until an agreed date. So even if I decide I don't want to sell it anymore, I've given her an option until the end of April. In the middle of April, I decide, but I was stupid. I need it. I don't want to sell it. I cannot change my mind. If she comes to me and says, I'm buying it, I have to sell it to her. I am bound to honor my offer. A right of preemption, on the other hand, there is no offer. So with an option, there is the main offer coupled with a secondary offer. I just want to, don't know why my spacing has gone crazy here. A right of preemption.
Miss, before you go on.
Yes, please, screenshot.
Can you give example again? What's the main offer? And because I can understand that the second agreement is it's when you give an offer to somebody until a certain time.
Okay, the main offer is whatever it is. In the example I used, my main offer was to sell my cell phone to you for $1,500. That's the main offer. The option is the second agreement that I will keep that offer available to you until a certain period of, until an agreed date. In our example, the end of April. So until the end of April, that offer, the main offer, selling the cell phone for $1,500, I cannot withdraw it. I cannot change my mind. I cannot sell it to anybody else. At any time before that cutoff date, you have the right to accept it. Even if I no longer want to sell it, I have to sell it to you.
Oh, okay. Thank you,
Okay.
Miss.
Okay. But please, while I'm teaching, while I'm typing, I have the screen with a sheet where the page where I'm typing my notes open in front of me. So I don't have the window with a class in front of me. So if you don't understand something, please do what Paulina just did. If you just raise your hand, I'm not going to see you. So please, if you're not sure about something, thank you, Paulina, for doing that. Just shout out, call my attention, and I will give you the. So ask your questions if I'm doing something that you don't understand. Okay, so right of preemption. A right of preemption is similar to, sorry, it's not a, it is a right of preemption, but in the study notes, we actually use the term preferential right. I just don't want to confuse you. Don't know why my spacing has suddenly gone wild. So a preferential right, also known as a right of preemption, or also known as a right of first refusal. With an option, there's an offer. With a preferential right, there is no offer. No offer has been made. It is simply an agreement that if I decide to make an offer, it will, I will make it to the holder of the preferential right. So Paulina asks me if she can buy my cell phone. And I tell her, well, I'm not selling it at the moment. And she says, if you decide to sell it, can I have a preferential right? And I agree. So in 3 months' time, I decide to sell it. I must first offer it to Paulina, and she has the right to accept my offer or reject my offer. If I've given a preferential right to Paulina, I cannot legally sell it to Machiwa before having offered it to her. So there is no offer in existence, merely an agreement that if I decide to make an offer, it will be addressed to the holder of the preferential right. An option, on the other hand, there is already an offer on the table. So while the offer, remember, we're looking at consensus consisting of offer and acceptance. While the offer is still open, there's the offer, all the requirements have been met. While it is still open, it can be accepted. Also look at the requirements for acceptance. There are requirements for the offer. There are also requirements for acceptance. The most important requirement for acceptance is that it must be unconditional and unequivocal. So simply, yes. The moment you say yes, but it is not an acceptance, it is a counter offer. So, cell phone for $1,500, offer is complete and definite. You say yes. There's offer, there's acceptance. Cell phone for $1,500, yes, but only for is a counter offer. It's not an acceptance. So you accept the offer as it is, complete with all the details. Not wanting, the moment you want to negotiate about something, that is not an acceptance, that is a counter offer. Everybody with me so far?
Yes, Miss.
Okay.
Means that at the acceptance, the requirements, so there's no negotiation, like at the optional offer.
Come again?
I'm saying you said at option offer you can, like here at acceptance the requirements. So you say it is unconditional. You cannot maybe say, okay, I have this this amount, while you ask maybe a higher amount and a lower amount, and I said, no, I only be able to buy at this.
Yes. Then if you say, I can only buy it for this, you aren't accepting the offer. You are in fact rejecting my offer and making a new offer, a counter offer. So I say $1,500 and you say, I can only buy it for 1,000. What you've actually said to me is, no, I will not buy it for $1,500. So you've rejected my offer. And then you have made me a new offer. I can only buy it for 1,000. That is a new offer, which I can then say yes or no. Or I can say, no, not 1,000, 1,250. So I've rejected your offer, put another offer on the table, which you can then. So we can keep going back and fro until we both agree or until we both realize, okay, this is not going to work. You're not going to buy it from me. So offer and acceptance is essentially negotiation until you reach a complete agreement where you are both on the same page. Are you with me now?
Yes, ma'am.
Okay, wonderful. So that was unit 2. So moving on now to unit 3. Factors influencing consensus. Sometimes, let's go back to where we started. There must be consensus for the contract to be valid. If there's no consensus, the contract is void. There are no rights and duties. There is no contract. A contract, however, can sometimes be voidable, which means it is valid but there is something wrong with one of the requirements, in most instances, the requirement of consensus. So there is consensus, or maybe there isn't consensus. Contract is voidable, it can be set aside. The first factor influencing consensus that we're looking at is mistake. What is mistake in terms of the law? Pretty much similar to your ordinary English meaning of mistake. To save some time, I'm going to do a copy and paste here. A mistake is a misunderstanding or mistaken perception of the identity of the other party or the obligations of one or both of the contracting parties, which influences the mistaken party's decision to contract. Now think carefully. Need you to work with me here. In order for there to be a valid contract, there must be consensus. Consensus, I'm going to copy and paste so it's easier for you to think with me. A complete agreement about the same thing, the same understanding about the obligations. Mistake, I've just told you, is a misunderstanding, a mistaken perception about the identity of the contracting party or the obligations. When I started teaching, I used the example when we started talking about consensus. I used the example of Paulina handing her cell phone to Machiwa. Machiwa thinks this is a gift which he can keep. Paulina is under the impression or thinks that he's going to use it for the day and give it back to her tomorrow. So they do not have the same understanding about the obligations. Is there consensus? Quickly tell me. Paulina hands her cell phone to Machiwa. She's expecting to get it back tomorrow. He thinks he can keep it forever. Are you in complete agreement, yes or no?
No.
No, you are not in complete agreement. Obviously not. So is there consensus between you? Yes or no? Have you reached consensus?
No.
No, you haven't. This is not that difficult. This is common sense. So you don't think you're not on the same page. When Machiwa took the cell phone, when he accepted it, he thought, he was under the mistaken belief that this is a gift, that he can keep it forever. So his thinking that he can keep this forever influenced his decision to take the phone. But there's no consensus. If there's no consensus, the contract is void. There is no contract between you. You are not bound to give him the contract forever. He does not have the right to insist to keep it forever. There was a mistake. There was a misunderstanding. There is no contract between you. The contract is void. It is, however, not every mistake that will make a contract void. The requirements for the contract to be void is that the mistake must be reasonable. Firstly, the mistake must be material. So it must relate to a fundamental aspect of contract. A material mistake. He thinks he can keep it forever. You want it back. That's a material mistake. It's integral to your whole agreement. A mistake that is not material, the phone cover is black, but he thinks it's dark blue. The contract will not be void because the color of the cover doesn't go to the root of the contract. The mistake must be material and it must be reasonable. The type of mistake that an ordinary, reasonable person under the same circumstances would have made. Then on, let me just get this page reference. On page 10, on page 10 of the notes, there's a short discussion of types of mistake and which ones are considered material or not. You do not have to study the different types of mistakes. I will not assess you on that. So just make a note of that. You get a mistake regarding identity, mistake of fact, mistake of performance, mistake of quality, blah, 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 blah. I will not be assessing you on that. The next factor, so a mistake, we're looking at factors influencing consensus. The first one looked at is mistake. How does mistake influence consensus? Mistake influences consensus in the sense that there is no consensus. The contract is void. The next factor that we look at that could potentially influence consensus is misrepresentation. Let's get the definition of misrepresentation out for you. Misrepresentation, an unlawful, untrue statement about an existing fact or state of affairs made by one party to the proposed contract to the other contracting party before or at the time when the contract is entered into, with the aim of inducing the aggrieved party to enter into the contract. Misrepresentation, to give you an example, is I offer my car for sale for $300,000. And I tell you that the car is in a perfect working order. You subsequently agree to buy the car for $300,000. Is there consensus, yes or no?
Sorry, Miss, what's the example again?
I offered to sell you my car for $300,000. I tell you the car is in a perfect working condition. You agree to buy the car for $300,000. Have we reached consensus?
Yes, ma'am.
We have reached consensus. There is an agreement. Now you take delivery of the car, and 3 days later you realize that I was lying to you. The car is not in a perfect working condition. I made a misrepresentation. I made an unlawful, untrue statement which induced you, persuaded you to enter into this contract. We have consensus. You have agreed to buy this car. But this agreement that we reached, this consensus that we reached, was based on my unlawful, untrue statement, on my misrepresentation. So it was achieved in the wrong manner, which means there's something wrong with the consensus. It is there. If there's mistake, when there was mistake, there was no agreement. Here we have an agreement, but there's something wrong, which means the contract is voidable. Voidable means the innocent party can set it aside. So you agreed to buy it. It's a valid contract. But because your agreement was based on my misrepresentation, when you find out what the true situation is, you can set it aside. You can say, no, I'm not continuing with this contract. Or if it's not that bad or whatever, you decide not to set it aside, it remains valid. Are you with me there? Do you understand that concept? Now we get different types of misrepresentation. You get innocent misrepresentation, negligent misrepresentation, and fraudulent misrepresentation. Innocent misrepresentation is where I make an unlawful, untrue statement. I say something which is not correct. However, when I'm saying this, I actually honestly believe it to be true. I offer you my car and I tell you it's in a perfect working condition because it has a complete service record. I've been taking it to services. I've been checking oil and water on a regular basis. It has not given me any problems. After you take delivery, we realize that actually there is something wrong. But when I said it's in a perfect condition, when I made this misrepresentation, I honestly believed and had reason to believe that what I am saying was true. It wasn't true. It wasn't correct. It's still a misrepresentation, but it was made innocently. Contract is voidable. You can still set it aside. Negligent misrepresentation. I thought what I was saying is true, but I had not been acting like a reasonable person. I did not make sure that what I'm saying is actually true. So I tell you the car is in perfect working condition, but I haven't had it serviced for the past 2 years. So I don't actually know whether what I'm saying is true or not. I was negligent because I didn't check. Can be set aside. And in addition, the innocent party can claim damages. Damages, monetary compensation for any money that you lost. So if it broke down in Okahanya and you had to get a shuttle to bring you back to Windhoek and pay tow-in costs or whatever, monetary expenses that you incurred, you can claim these back. Fraudulent misrepresentation, exactly what it is. I know I am telling a lie. I know the engine is making funny noises and I haven't checked it out for years. But I tell you a blatant lie. Fraudulent misrepresentation, same as negligent, can be set aside. And then you will have a claim for damages. Everybody with me? Paulina, are you with me? Mashiwa?
Yes, ma'am.
Okay. So other factors that influence consensus. In your notes, I have lumped them together. In most legal textbooks, they are normally discussed as two different factors. There are two different factors that can influence consensus, sometimes based on a factual scenario. The lines might be a little bit blurred. It might not be that easy to distinguish, is this now duress or is this undue influence? Which is why I have put them together. I'm going to give you the definitions quickly. Duress, an unlawful threat of harm or injury made by one contracting party or someone acting for that party, which causes the other contracting party to conclude the contract. So, as is the case with misrepresentation, you agreed to buy the car because I told the lie. Now, I'm going to get back to undue influence. Let's talk about duress first. Now, listen to me carefully. Something that I often tell my law students: think with your heads, not with your hearts. Students often tell me, but I don't understand that. You don't understand it because in your heart it feels wrong. Law is not about how it feels in your heart. It's about how do the principles work. So, Paulina.
Yes, ma'am.
I say to you, buy my car for $300,000 or I will kidnap your mother. And you know that I have the capability to kidnap your mother. Because you believe that I will kidnap your mother if you don't agree to buy my car, you say yes. Have we reached consensus? Do we have an agreement?
Yes, but
Yes, but the yes is the important bit. And this is, students struggle to understand this. I made a threat. I threatened you. And because of that threat, you said yes. The bottom line is you said yes. There is consensus. We have reached consensus. You agreed. You said yes. There is consensus. But now you started saying yes, and then you giggled, you said but. Where does that but come in? There was consensus, but it was achieved in the wrong manner. I achieved consensus by threatening you. So there's consensus, but there's something wrong with it. I achieved it in the wrong manner. The contract is voidable, which means you can get out of it. You said yes, and it's important that you understand this, please, people. There is consensus. As Paulina said, yes, she agreed. The but part comes in. She agreed because I threatened it. We threatened her. Because I threatened her, the contract is voidable. And she'll be able to get out of it. She'll be able to have it set aside. Are you with me there? It's important that you understand that as Paulina said, yes, there is an agreement. She agreed. Yes, but the law protects her under circumstances like that. Contract is voidable. She can set it aside. But it starts off as valid. And if she decides, well, even though she was threatened, it's still a bargain and she wants to keep it, it remains valid. Undue influence is similar. Undue influence, improper, unfair conduct by one party that persuades the other party to conclude the contract. Duress, a threat of harm or injury. Undue influence, similar, but rather a situation where one party is in a superior position. Undue influence would be if I say to Paulina, buy my car for $300,000 or I will make sure that you never pass sports law. She agrees. Did we reach consensus? Paulina, did we reach consensus? Machiva, you can also speak
yes,
up. Sorry,
if
I
I
didn't hear
say
you. You
if I
said yes.
say yes, then we'll
Yes.
reach that. But
With once again, exactly. You've got wonderful insight and understanding here. We've reached consensus, but it was based on my undue influence, the fact that I'm in a position of power. I told you, if you don't say yes, I will make sure that you never pass. Similar to duress. There is consensus. You said we have agreed, but because I made you say yes by using my position of superiority, my more senior position, whatever, the contract is voidable. If you don't want to continue with it, you can have it set aside. As you said, yes, but that's important, that understanding that it's yes, but there is consensus, but it is voidable. Everybody with me? I think so. Okay, so that is unit 3 that we did, the factors influencing consensus. Moving on to unit 4. Sorry, I'm just looking for my notes. Just give me a second. Okay, I don't, for some odd reason, seem to have a hard copy of unit 4. That's not the end of the world. I know what is in unit 4. I'm just going to open it in a different window on my laptop for page references. So unit 4 then, so what we've looked at so far, if we can just recap, we've seen that order for a contract to be void, there are 5 requirements. and all 5 these requirements must be present. It is sometimes said that consensus is the most important requirement. A contract is an agreement. Consensus is an agreement. Without this agreement, there will be no consent, there will be no contract. It is not, however, correct to say that consensus is the most important requirement. Potential assessment question. Oh, sorry. True or false? Motivate your answer. Question that I can ask: is consensus the most important requirement? I've said this moments ago. People often say it is because consensus is an agreement, contract is an agreement. Without consensus, there is no contract. It is not, however, correct to say that consensus is the most important requirement, because there are 4 more requirements. And even if there is consensus, if these other requirements are missing, there is no valid contract. The contract is void. You can agree until you're blue in the face. If you're only 16 years old, the contract is void. You can agree until you're blue in the face. If the performance is not possible, if the performance is not legal, the contract is void. So no, it is not correct to say that consensus is the most important requirement. So we finished looking at consensus. Unit 4 deals with the further requirements. Although they are discussed more shortly, more briefly than consensus, 2 units on consensus, the rest of them are also all together in one unit. That does not mean that they are not as important as consensus. So first of all, legal capacity. In order for the contract to be valid, parties must have legal or contractual capacity. What does this relate to? Contractual capacity relates to the ability to understand the significance of your actions. Consensus is a complete agreement. We saw one of the requirements is for parties to have reached consensus is there must be a complete understanding of the obligations. In order to have this complete understanding, you must actually be capable of grasping it, of understanding it. You must be able to comprehend the significance, the obligations, what the consequences are. Contractual capacity influenced by the age of the person as well as by your mental health. Those factors can influence your ability to completely understand what is being said or what is being agreed to. With regard, there are other factors as well, but we just look at these. The other factors like your marital status, etc., can also affect your contractual capacity. That is outside the scope of our studies. We only look at age and mental health. So age, below the age of 7, cannot contract at all. There is no contractual capacity. So I'm just working. I don't know why my spacing is going haywire the whole time. So below the age of 7, there's no contractual capacity. Between 7 and 18, 18 is the age of majority in Namibia. In terms of the Child Care and Protection Act, age of majority is 18. So between the age of 7 and 18, you have limited contractual capacity. You can enter into certain contracts on your own. There's a statutory list of contracts that you can into on your own. These actually fall outside the scope of our studies as well. But just to give you some examples, under the age of 14, so between 7 and 14, you can consent to HIV testing. 14 older, you can consent to surgical operations, medical care for yourself, as long as the medical practitioner, the doctor, is convinced that the child understands. You can, at a certain age, you can open your own bank account, etc., etc. So there are certain exceptions between 7 and 18. Limited contractual capacity. You must be assisted by your legal guardian to contract. So legal guardian, either of the parents, or if the parents are deceased, a guardian appointed by court, must co-sign, must assist you to contract. However, there are exceptions, but you do not need to study these exceptions. Above the age of 18, above the age of 18, generally, You have full contractual capacity. I say generally because your contractual capacity above the age of 18 can be influenced by, for example, your marital status, whether you're married in community of property or out of community of property. It can also be influenced by your mental health. But in general, if there are no, if the exceptions, there are exceptions, let's just make a note. If the exceptions have not come to play, then you have full contractual capacity. You could enter into any contract without any assistance. With regard to mental health, in the notes, I have discussed two aspects. Don't actually like the word insanity, but it's still uh, used in legal terms, though it's not actually, or I don't think that politically correct anymore, that PC, to say somebody is insane. However, you can get a court order. You can be, the High Court can declare you insane. I prefer referring to declared mentally incapacitated by the High Court. If you have been declared mentally incapacitated by the High Court, you have got no contractual capacity. So you're on that level, cannot enter into a contract at all. However, there have been cases where even a person who has been declared mentally incapacitated can have a clear moment where they actually understand the consequences of their decision and can contract. The way the law works in this instance is that the person, the party who wants to hold them to the contract, must prove that they another mental situation, not specifically health, but another situation that can affect your ability to understand. It is intoxication, being drunk. if I have, sorry, my top dog here. Excuse me.
I miss what's going on. Hello?
Probably network. No?
Yeah, perhaps.